Now, I want to bring in Lisa MacCarley to the show. I'm so honored that she would be a guest here because she is all over Twitter. If you following Free Britney on Twitter, you see Lisa MacCarley's tweets. This is the real expert. She knows probate and she knows that case. And here she is.
Hi, Chris.
Now, Lisa, thanks for joining us. And I want to just, lay that out a little bit more. This is what you do, right? I mean, you're a probate attorney. You're in this system. How long have you been doing this?
Actually, I went to law school in the 1980s because I wanted to be of service to families that are dealing with difficult problems related to aging relatives and disabled adults. So I've been doing this my entire career, and I went to work for the first time in a law firm in 1990. So I've been doing this for quite a long time.
Now, one of the things, Lisa, that's super confusing to me is this concept of a voluntary conservatorship. And if you can walk us through that, and what seems contradictory to me is that somebody who allegedly is incapable of handling their own affairs could possibly consent to anything. And secondly, how could they possibly understand the ramifications of a conservatorship giving away rights for potentially ever? So if you can walk through for us, what exactly is that?
Well, it's very rare, actually, for a person to petition to conserve themselves. It sometimes happens, but typically it is because of family conflict that the subject person wants to mitigate or dissolve. The problem that you have correctly addressed here is that did Britney Spears get all of the legal advice that she needed to make an informed decision? Because essentially what has been told to the public is that she agreed to give up, forego her civil liberties, her self-autonomy as a person, as a woman, and I'm not sure that that is a correct characterization of what happened now that she has revealed that she may not have been given correct counseling even about the right to terminate this conservatorship. So your question is astute. If she cannot manage her own needs for food, clothing, and shelter, how can she possibly voluntarily and knowingly give up her civil liberties? It is a contradiction.
Now, Lisa, we've also heard there's never been a determination of incapacity by the court. I assume because this was a so-called voluntary conservatorship. So, number one, is it true that there's nothing in the court record that shows that the court ever made a finding that Britney is incapacitated? And if that is true, what does that mean for her ability to get out of the conservatorship?
Well, you're absolutely right, and I've scoured through the records. For one thing, I don't agree that the correct characterization of this conservatorship is voluntary. We know that Ms. Spears attempted to retain counsel to oppose the conservatorship right in the beginning. The big question is, why was she denied the right to retain we all know the name Adam Streisand. So first of all, I don't believe that this was truly a voluntary conservatorship. She did try to get out of the conservatorship. I think what happened is when she was denied counsel, she finally capitulated to the conservatorship with the understanding that this would give her greater access to her children and to friends and family. So let's talk about that. I also understand that there has never been an adjudication of her incapacity. There's never been a proper filing by a doctor or doctor's statement. In probate, we call it a capacity declaration. And in my mind, that's going to make it very easy for her to terminate the conservatorship if she chooses to do so. But these are very troubling questions. What was Ms. Spears told? all of these years by her court-appointed counsel that allowed something so abusive and traumatizing to remain in place? Great questions.
Yeah, Lisa, and I heard the reporting about the concern that at least was stated to Britney by others that she might lose custody of her children because of the crisis that she was under, and that this conservatorship may have been sold to her as a way to avoid losing custody. And to me, as a divorce lawyer now in my world, that makes no sense at all, because the court will look at the best interests of the children, doesn't need a conservatorship over somebody if they're having issues. So if she was sold that story, it was really a bad one. And then again, taking away her chosen counsel, so she has nobody advocating for her, and more importantly, or just as importantly, nobody advising her. I could see how this thing has perpetuated. Now, one thing that's also confusing to me is that it was very easy, it seems like, for her to get into a conservatorship. Why is it so hard now for her to get out of it? Why wasn't it good enough on June 23 when she addressed the court and said she wanted to end it and gave her reasons for it, to end it? And I understand there's court process and it wasn't on hearing that day, but what do you think that the court can push this along quicker than a normal case?
To be very honest, I have been very bold and aggressive about making sure that the judges, especially the presiding judges in Los Angeles County Superior Court, are aware of the procedural defects, which are significant, which took place in February 2008, which led to the imposition of this conservatorship. It goes even farther beyond not having counsel of her own choice. Ms. Spears was not given the documentation, and immediately Commissioner, now Judge Reva Getz, denied her access to other attorneys other than her court-appointed lawyer. So it is possible, although admittedly not probable, but there is a chance that Judge Brenda Penny, who has a lot in stake in terms of her long career in the probate courts, she might pull the trigger based on what Britney Spears stated to all of us on June 23rd. I think it is more likely that the new attorney will come in and file some type of writ or motion to explain that this case started with numerous violations of Ms. Spears' constitutional rights. And for those reasons, I'd like to see this terminated as quickly as possible. But otherwise, it is a long process. However, it's clear. It's been clear to the Free Britney movement and to anyone that has observed Ms. Spears performing either as a judge or in Las Vegas, that she is clearly capable of providing for her own needs for food, clothing, and shelter.
Now, Lisa, one of the phrases that I thought I read in one of these court papers was that she was a high-functioning conservatee. To me, those words should not be appearing together, that somebody who's high-functioning would think not need a conservator or not need certainly this level of protection. So are there other situations that you're aware of, or any explanation that you could give, that somebody who's able to work, and not just a regular 9-to-5 job, we're talking a Las Vegas residency, which would be grueling, who's able to earn a living to pay for all this stuff, able to post on social media, need any of this protection?
You're so absolutely right that it does seem that this was an extreme overreach in terms of what transpired. And to be honest, I think that the court owes it to Ms. Spears to review the documentation. And part of the big problem that I see here is that the bench officers rely so much on the court-appointed attorneys that the power dynamics now are such that it is actually in Los Angeles County Probate Court pretty much an unwritten rule that the judges will follow the recommendations of the court-appointed attorneys. And this ended up being problematic these last 13 years, because it is my understanding that the court-appointed attorney has had a standing order that he is to receive a weekly stipend of $10,000. So right off the bat, starting in 2008, there was a terrible conflict between the court-appointed counsel and his client. So not only did he, the court-appointed attorney, testify at the initial stages of this conservatorship that Ms. Spears lacked capacity to retain her own counsel, even though she did retain her own counsel, it was really a bad setup from the beginning. And I do take issue with the fact that there was a standing order, which was an amazing amount of compensation to this man who was supposed to be advocating solely for Britney Spears. And now it comes out that she's been asking for years to have the conservatorship terminated. Let me take care of it.
Yeah, it's just so disappointing. There's so many issues in this case that are disappointing. And one of the things that I read that Mr. Ingham had wrote in some of his paperwork was stating that Britney Spears had been determined by the court to be incapacitated, when we know that never happened. And I just wonder, like, how is it that the rest of us know that, and the lawyer that's made potentially millions of dollars or certainly hundreds of thousands of dollars off of this case doesn't know the case file? That blows my mind. So I want to ask you in conclusion about the system here and how other people are affected by it, because we're talking about Britney Spears, but there's a lot of people under conservatorships. And does this system self-perpetuate? Are judges reluctant to release somebody for conservatorship because they're worried that something's going to happen to them and that they're going to be blamed for it? And does that just basically cause these things to go on forever?
This is a very unusual case, and I am not aware of many instances where a conservatee showed up and said, I'm perfectly capable, here's a doctor's declaration, here's my family to support me getting out of conservatorship. I have certainly terminated conservatorships, and frankly, we know that the court-appointed attorney has done so as well. What is unusual and what needs to be addressed immediately, and this is where I think that the Free Britney movement did such a marvelous job, we need to understand, why are the judges taking the word of court-appointed counsel when we know that these are supposed to be advocates for a person facing or in conservatorship, and not looking at the bigger picture, which is, how do we remain within the framework of the probate code? And one of the important provisions that seem to have been completely overlooked is what is stated as, we need to find the least restrictive alternative to conservatorship. And that never appears to have been explored and investigated. So I will say, in defense of the probate court, I don't know of many people that are conserved inappropriately. I do know of many people that have been left in abusive situations, notwithstanding reports and investigations that cried out for a change in the conservatorship. And this needs to be dealt with as quickly as possible.
Well, thanks, Lisa, for that insight. And it's really, one of the wonderful things about social media is just getting to know people. And Lisa and I got to know each other and correspond here via Twitter. It's such a great place to exchange these ideas. And I really appreciate you coming on the show and giving that expert advice that we need to break it down. So thank you very much.